All right, to comply with open courts, we've got to get to YouTube so people can see us. So we're now live on YouTube. All right, Mr. McCall, I'm sorry.
Thank you, Judge. As I mentioned, I'd like briefly to go over, at least from our viewpoint, Mr. Thagger's viewpoint, where the case is at the moment. In November of 2020, this court, in response to a summary judgment motion, ruled that XTO take nothing against Mr. Thaggart on money hadn't received claims. And then in September of 2021, Mr. Thaggart moved for summary judgment, second motion for summary judgment, on the grounds that XTO had breached its division orders by seizing and withholding revenues owed to Thaggart from non-disputed sections, that they breached the Natural Resources Code when they seized and withheld production revenues owed to Mr. Thaggart from the non-disputed sections. We sought judgment against XTO for recovery of all proceeds of production owed to Thaggart and withheld by XTO from the non-disputed sections, and we sought recovery against XTO its reasonable attorney's fees and in an amount to be determined at a later hearing. And the court granted all of that, all those requests in their entirety on September 9th, 2021, holding that the motion was granted and that Thaggart was entitled to recover from XTO the sums that XTO withheld in connection with the non-related properties. And so that's the basis of the motion that we had filed seeking disbursement of these funds. And I'd like to, it seems like to a certain extent that parties have gotten away from, at least XTO has gotten away from the basic rulings in Govinda that, and the Texas Supreme Court has spoken at length on this, not only in Govinda, but other cases, is that in a situation where the royalty owner is overpaid and a corresponding royalty owner is underpaid, that the operator has, in this case XTO, no cause of action against the overpaid party, and that the underpaid party has no cause of action against XTO in this case for being underpaid, and that the sole remedy between all the three parties is that the underpaid party can bring action for money hadn't received against the overpaid party, which in this case, Mr. Cass files such a claim against Mr. Thaggart, and the court granted summary judgment against Mr. Thaggart for the full relief that the law allows under money hadn't received for the funds that Mr. Thaggart received 2 years prior to the date that the counterclaim by Mr. Cass was filed. And that should have ended the dispute based on existing case law, but XTO, knowing that Mr. Cass could not recover more than 2 years, decided early on that it would claim ownership of Cass's money that it could not recover and take it from Mr. Thaggart as a newfound source of revenue, as a windfall. And so they went and they seized from totally unrelated properties. They seized several $100,000. They're close to maybe, I'm not sure what's in there now, $260,000. And that's the money that we're seeking to have dispersed. This is not a trial on the merits. We anticipate that we would like to take this case to trial, the earliest possibility of hearing on attorney's fees and interest, but That's not before the court today. Now, XTO would characterize the money that it's taken from Mr. Thagard as, well, I'm not sure what their position is. There's certainly no legal basis to hold that money. It was never their money. It belonged to Mr. Cass. And XTO has claimed the right to take that money under the terms of the division orders, which require Mr. Thagard to pay money back to XTO for money it didn't receive, but that provision is only applicable to funds and monies that XTO would pay Mr. Thagard that actually belonged to XTO with its own money, not with somebody else's. And that's all that is addressed in the prior case law in Texas. And so XTO has no claim to that money. They filed a claim for offset recoupment, and they lost on the summary judgment motions on that. Statute of limitations. The court may recall the arguments that we made about recoupment set off. Recoupment is rarely recognized in Texas. That's where there's corresponding offsetting debts between the parties in the same transaction, which in this case, there is no debt that Mr. Thagard owes to XTO under Govinda because the division orders are binding between the parties. So recoupment is not applicable. And so in situations where somebody tries to impose set off, like in this case, by going to outside properties, there also has to be corresponding debts. There is no debt that is owed. The division order does not create a debt. XTO is not entitled to be paid money that it has no claim to. And set off has to be asserted affirmatively as a counterclaim, as it was by XTO, and is subject to 2-year statute of limitations, which this court imposed and barred as barred any recovery on money hadn't received, and that would include the claims on set off. So we find ourselves today with a set of money that money in the registry of court that nobody else has an interest in, but Mr. Thagard. It has nothing to do with sections 32 and 41. This is solely an issue that affects no other party in the case except XTO, Mr. Thagard. I think XTO has at one point alleged that it's entitled to hold the money in case Mr. Butler recovers sums from XTO for 4 years instead of 2, but the 2-year statute of limitations governs that cause of action. They've already received, Mr. Cass has received the full recovery that it can. XTO doesn't need to hold any money of Mr. Thagard's just in case it needs to pay Cass for 2 more years. When he's already recovered against us for all that the law allows. And so we believe that pending the ruling of the trial on this case, which we intend to bring about as quickly as possible, we request that the court go ahead and authorize the dispersal of that money on the grounds that XTO has no conceivable claims to that money and cannot prevail under any legal theory.
Okay, Mr. Aurelio.
Judge, I feel like this may be the 5th time that we've heard argument on the merits of these various different claims. That's not the motion that was set for today. The motion that is set for today is effectively a request by the plaintiff to be paid on its claim before there's been a final judgment entered, before we've had our affirmative defenses adjudicated, and before we've had our counterclaim adjudicated. There is no authority to be able to collect money on a claim before judgment. I mean, that's just the reality of it. And instead, The Texas case law shows the opposite. And so in our response, which we filed this morning, I cited just three cases as a sampling, really, of circumstances in which courts of appeals granted mandamus to overturn trial court orders that had ordered funds to be placed in the registry of the court because there was no evidence to show that there was a risk of loss or depletion of those funds. And so those are cases in which there's an interim step of just depositing the funds in the registry of the court. All those cases, the court said there must be evidence of some risk of loss of the funds, or you have to satisfy the requirements for a writ of attachment under Chapter 61 of the Texas Civil Practice and Remedies Codes. If you're going to try to get money out of the defendant's pocket and into the registry, there has to be a showing of some sort. There wasn't a showing there. Those cases were mandamus on that interim step. The plaintiff here is asking to go even a step further than that with no evidence and no authority to support it. Here, the plaintiff is asking, the funds are already in the registry of the court, which XTO did voluntarily. There was the judge, Your Honor, asked at our hearing on summary judgment if we had any objection to putting those funds in the registry of the court. We said no, and that's where they are now. But the plaintiffs want to go a step further beyond those and say, let's take those funds out of the registry and pay the plaintiff. You're not allowed to collect on, there is no judgment to even collect on a claim before there's a final judgment. There's just no authority to support that.
Well, is there any claim for these monies? These are the other properties. There's not a lawsuit on those, is there?
So there's, yes, Judge, there's a lawsuit that the plaintiff filed. The plaintiff's claims were twofold. One, they claim to own the overriding royalty interest in sections 32 and 41. And secondly, from the beginning, they've asserted a claim to funds that had been withheld on the outside properties. XTO's counterclaims to those have been offset, set off, recruitment, money hadn't received, in breach of contract, in addition to our affirmative defenses of offset, set off, and recoupment. And the only one of those that has been ruled on was money hadn't received. And the premise of the offset recoupment defenses is the idea that to the extent there are mutual debts, you apply those against each other. And so in this case, we have asserted counterclaims to claims of money that the plaintiff would owe XTO under the breach of contract claim under the division order. And that's associated with the fact that XTO paid the plaintiff over $600,000 on an interest that the plaintiff has been ruled did not own. And so to the extent that there's a recovery on that, well, then there's an offsetting debt. And so as opposed to, the case law refers to it as A paying B when B owes money, those debts get applied to each other, and whoever comes out ahead would be the one that would ultimately get the recovery there. And so the offset goes or the recoupment, they kind of all fall under the same label. They all go to the circumstances of what would be the damages that could ultimately be recovered by the plaintiff. If the plaintiff is entitled to recover $200,000, but XTO is entitled to recover $300,000, well, then applying those debts against each other, XTO would get $100,000, the way that would work out. But in this circumstance, the plaintiff is seeking to be paid that $200,000 out of the registry of the court before there's been any judgment on that, before we've had an opportunity to appeal that decision, before we've had an opportunity to present our affirmative defenses on that situation. And in these circumstances, whenever there's a situation of a requirement for a pre-judgment, whether that be payment or whether that be pre-judgment placing funds in the registry of the court before there's been a final determination, the Texas Courts of Appeal are clear that there has to be some underlying justification for that, separate and apart from the merits. And that underlying justification, whether it's an attachment or whether it's a situation involving funds in the registry of the court, has always been, is there a risk of those funds being lost or depleted? Here, there was no such risk, but even if there were, the most that the plaintiff would be entitled to would be to put the funds in the registry of the court so that they're protected in the event that once the case is finally disposed of, there would be the funds there. So there was no longer that risk of loss. that was the best case scenario, and we've already done that voluntarily. And so there's no basis to release those funds to the plaintiff when there's no evidence of concern about loss of depletion, when there's been no satisfaction or attempt to satisfy any sort of writ of attachment under Chapter 61. And so there's just really no authority to release these funds. Now, I mean, really what feels like what's animating the concern here is that the case is still pending and plaintiff hasn't had an opportunity to complete it. But that's not XTO's fault. I mean, there's, as the court knows, there's a number of different parties in this case, many of which are not on this call. And we're just, for the most part, just a bystander in this, just a stakeholder trying to figure out who owns what so that the funds can be released. And so we can't force the parties to press this action any further. And so ultimately, Judge, I think that the case law that we've cited shows that there is no authority for the request that's being sought. There's an assumption underlying the plaintiff's argument that there's just no more defenses left or no more breach of contract. But that's just, I mean, or no more counterclaims, but that's just not true based on our pleadings. None of our affirmative defenses have been ruled on, and all of our affirmative defenses go to the question of damages. And in the court's order, granting summary judgment that the plaintiff referred to, that this entire motion is based on, the court stated that the amount of damages, and if any attorney's fees, will be determined at a later date. So there's already no order on damages to begin with. But even if there were an amount set to that, we're still entitled to present an offset or a recoupment defense to apply mutual debts against each other, and we still have claims pending on that. We haven't been pushing them because really what we're concerned about is having to pay somebody else money that we've already paid to the plaintiff, and so now we're paying twice. And as much as we can sit here today and talk about the Govinda decision, I mean, that's not an issue that's present, and those are still risks that, and it's not an issue that's been ruled on in the rulings. And so we'd ask Judge that this motion be denied outright, as there's no basis to support such a release of the funds.
All right,
I'd
Mr.
like
Taylor.
to briefly respond if it's okay. There's no disputing that these are not disputed funds. These are funds that belong to Mr. Thacker. And it's kind of a curious, and Mr. Guido is correct. There is no judgment. Yes, XTO, without the benefit of a judgment, decided to seize, grab money from Mr. Thacker to use his own money to offset any recovery that he might obtain against XTO. The only recovery right now that XTO is being subjected to is that Mr. Thacker wants his money back. And there's no basis for it to hold it. Now, contrary to XTO's arguments, the issue of set-off recoupment has already been tried and heard, and the issue court ruled against XTO on those grounds. Now, again, the Supreme Court of Texas has said with regard to recoupment that it has no place in the jurisprudence of Texas. They've modified that briefly, but only in very limited sections or instances. And the only time that recoupment can be used is defensively, not affirmatively. Unlike set-off, which is recognized in Texas, as long as there's mutually offsetting debts and obligations. And XTO asserts that there's a debt that's owed by Mr. Thacker to XTO for being overpaid, which is contrary to Texas law. I mean, the Supreme Court has told oil companies repeatedly that if you overpay somebody, you don't have a cause of action against them. That's between the overpaid and underpaid parties. So first of all, there's no debt. And XTO is not really in the position of a stakeholder. It's an active participant in finding a way that it can make Mr. Thacker pay all the money that Mr. Cass would allegedly have been entitled to had the statute of limitations not run. So to XTO, that is the source of, it's a windfall. It's a source of newly found money that they can use other properties of Mr. Thagard to pay back. And that's totally contrary to existing law. And there's no basis for XTO to continue to hold funds, even under recoupment or set-off theory, because.
We can't hear you. We're struggling up here.
Oh, really? Okay.
Yeah, there you go.
Okay. Certainly, you can't hold the funds to Mr. Thagard. They use his own money to offset any recovery he might get against XTO. So, in order to this court is going to have to make the following findings to have XTO's position sustained, and that is it's going to have to find that, in contrary to Govinda, that Mr. Thagard does in fact have to repay XTO for money it got paid that should have gone to Mr. Cass, even though Govinda says there's no such liability. It's also going to have to find that the division order that Mr. Thagard signed, contrary to the holding in Govinda, requires that Mr. Thagard pay XTO for money that Cass should have received but did not, money that doesn't belong to XTO, never belonged to XTO, and that they have no claim for it other than the wording of a division order that requires indemnity in the event they use their own money to pay Mr. Thagard in a way that he becomes overpaid. There's no obligation. No court in Texas has ever held or even seen the position that's being presented by XTO in this case. This is a case of first impression as to whether or not, in a way, without saying so, XTO is effectively asking this court to overrule Govinda. Now, whether or not they're making a good faith effort to do so, the parties in this case are bound by Govinda. And XTO just flouts that by filing suit against Mr. Thagard to recover money that the Supreme Court says you can't recover. And certainly, every instance where this issue about if somebody is overpaid, can an oil company go to other properties totally unrelated to the dispute and take money? And without fail, every legal scholar who has addressed the issue says, no, don't do it. And most oil companies don't do it. But XTO seems bound and determined that they're going to blaze a path that nobody's blazed before and seek, I don't know if this is a test case or whatever, but Mr. Thagard is an innocent party here. The dispute is in 32 and 41. Without the benefit of a judgment, XTO can't grab money to protect itself. It's like a prejudgment garnishment where it just takes money and says, I'm going to hold this in case you get a recovery. And if I do, I'm going to use your own money to offset it. Those are principles which have no basis, arguments which have no basis in Texas law and find no support in any case that's been presented by XTO to this court. So again, we would ask that the court recognize the prior rulings and the fact that there's no debt between the parties and that this money be released to Mr. Thagard in the event that the court were to find that XTO, that Mr. Thagard later in a trial owes money to XTO, why it can do like every other plaintiff or defendant in the lawsuit has to do, It can levy on property. It can do whatever it wants to do, but this money has been tied up for years and it needs to be released in order for this this case to go forward to the next stage, and that's a trial. So again,
All right.
we would, pardon?
Go ahead.
We would ask that the court release those funds.
Okay. Let me read any briefs. I haven't seen any briefing today on that. And Mr. Jones, do you have anything to add?
I'm troubled that Mr. Thagard is saying that the division order, Mr. McCall is saying that the division orders are essentially worthless pieces of paper when it comes to these claims. I mean, the division order clearly says that if you're overpaid, you're going to repay it. Now, if that's a contract, and if that modifies Govenda, so be it. It does. Now, I understand that Govenda is a cause of act. If the underpaid is a cause of action against the overpaid and not against the payor, and in this case, XTO is the payor, and I've got a separate controversy with them. But I just don't understand this argument that that's the way it has to be, and the division order has no effect. Division orders are binding until revoked. Some people have called them executory accords. Other people have called them contracts. The Texas Supreme Court refers to the division order as contract. I'm just troubled by that argument to you today. Otherwise, I have no dog in this fight. Thank you for asking for comment, though, Your Honor.
All right. Thank you.
Your Honor, may I respond briefly to
You
Mr.
may.
Jones? The division orders are binding between the parties as long as they're in effect. And they're binding between Mr. Thagard and XTO. And it was on that basis that the Texas Supreme Court has held that the payor has no cause of action. It directly addresses that situation and who can sue whom when this situation occurs. And that is that the payor has no cause of action against the overpaid party for payments made under this binding contract, as Mr. Jones describes it, although there's a conflict in Texas law as to whether even that's the case. But there's no question that they're binding between the parties. And they also said the underpaid party can't sue the operator. So the operator is completely protected in this instance. And there's this situation is not, I mean, it's unique because it's just one of the ways in which, like somebody like Mr. Thagard can get overpaid. An oil company can overpay no royalty owner like Mr. Thagard with its own money, in which event it's required to get that back under the division order.
Well, I thought with the indemnity provision in a division order, if XTO overpays somebody, then they can suspend funds until they make up their overpayment for that well.
Yeah, well,
Are you saying that's not true?
Not in the situation where it has no claim to the funds because the funds belong to somebody else. It's only in an instance where if it overpaid with its own money, can they impose the indemnity obligations. But if the money belonged to a third party and XTO had no claim of ownership to that money at all, it's the burden of the underpaid party to sue the overpaid party. And the division order does not come into play. Now, I agree with your statement, Judge, that in any event, any overpayment situation has to be limited, even if Mr. Jones were correct, which I don't believe he is. It has to be limited to the properties at issue because each individual division order, including the ones for the non-disputed properties, only operate as to the wells that are properties that are subject to those contracts. So there's no basis to go over to another county or another property where where there are no problems to start taking money prejudgment. And that's been the issue that we've had all along. And I don't know if Mr. Jones has a problem with oil companies doing that. I haven't talked to him about it, but I certainly do. And I think the industry as a whole does not support use of set-off in that instance because there's no Texas authority that allows it. Matter of fact, the law on set-offs is contrary to that in that situation. So that XTO is doing something that operators may have done in the past, but there's no authority for them to do that, particularly prejudgment where they're using our money as a defensive shield against Mr. Cass and against any claims that Mr. Thagard might prevail on in a subsequent trial of this case. So that's my response. And again, we would request that the court disperse the funds.
And Judge, if I may just clarify a couple of points on that, it's in response also to something that Mr. Jones said. One, just I think we've made this clear, but I want to reiterate it again. There was a lot of statements there about XTO's holding money. XTO doesn't have any of this money. The money
The court does.
there, yeah, the court has the ones that was pre-November 2020. Post-November 2020, XTO has been paying Mr. Thagard on those outside interests since that point. So XTO is not holding any money. It's in the court's registry, or Mr. Thagard is being paid it. Secondly, the division order was characterized as only referring to an indemnity. It has broader language in that. The division order says that if the payor pays the payee, Thagard, on an interest that Thagard does not own, which the court has ruled that Thagard does not own that override, then the payee, Thagard, agrees to indemnify and reimburse for those funds. And so the premise underlying this entire motion was that XTO had no claim at all against the plaintiff. But that division order that says that the plaintiff would reimburse the payor if he received an payment on interest that he didn't own, that's a claim. And so that's the source of the mutual debt discussion that we talked about earlier. I'm happy to, if we want to have I know the court has previously set a summary judgment deadlines in this case. If we need to have more briefing on this question and have a merits determination on these claims that are left, certainly happy to do that. But that wasn't the request that was brought up today. And so I just want to make clear that what was being sought today is a release of funds in the registry of the court whenever it has been acknowledged now that we still have a claim, that XTO still has a claim, XTO still has affirmative defenses. XTO's gone out of their way to no longer be holding any funds. They're in the registry of the court or being paid. It's just premature and improper to require a payment on a claim before a final judgment.
All right.
Your Honor, I want to address one thing that I think is important that has not been addressed yet, and that is Mr. Thagard has a judgment against him to pay Mr. Cass that money, whatever money that is that the evidence would show that was paid to Mr. Thagard for 2 years prior to the date that that Mr. Cass sued for that money. It should not also be subjected to having to pay that money twice to XTO and to Mr. Cass. There can only be one judgment.
Has Mr. Thagard paid Mr. Cass in full?
He's not paid him at all because the case is not final. I understand the parties are going to take an interlocutory appeal. That's the ownership of that interest, but certainly Mr. Thagard should not be. He's already got one judgment against him, and so now XTO is saying, "Well, you got to pay me too, and you got to pay both of us." And there's certainly no basis in Texas law for that.
Okay. Where are we on the interlocutory appeal? I don't show that it's been filed.
Well, we were, I don't know exactly where we are. We haven't had discussion about the last thing that we heard was the court had ordered that claim against XTO be severed because it's unique to the parties. The parties, no other claims, no other parties are affected by it. There were going to be other orders entered that were going to allow the remainder of the case to be the subject of an interlocutory appeal, and that's the last I had. I frankly don't know that Mr. Thaggart is going to be a party to that appeal or not, but that needs to be addressed by Mr. Cass's attorney and by RIM's attorneys on the issue, on that issue. But,
yeah, Judge, after the first hearing on it, the parties had looked to schedule a time to talk about what that would look like in terms of teeing up the issues for interlocutory appeal. And it seems as though the two primary title disputes here between really the largest interests are between Cass and RIM, and there just hasn't been, that I've seen, any real movement on that. So the only other thing I just clarify there, I don't know if it got lost in there, but there was that court actually denied severance. There wasn't a grant of severance.
That's what I thought. Yeah, we did not sever.
well, my recollection is that well, that could be the case.
Yeah.
But I know on it, and I believe the last ruling that the court made was court denied all severances.
I think that was right.
Right.
So
And
where are we with trial dates?
We're
In that, well, Judge, we don't have any, because the idea was that everything would stop while the interlocutory appeal went up, and then once the title issues were resolved, then things would know where to flow from there. And so there was no talk about a title dispute. I think it would be, if the court would like to give the parties on this hearing, maybe even if it's an informal one, a deadline by which to submit the interlocutory appeal papers, then maybe that could help kind of jumpstart things with the other parties and get this moving again. It's just, since our last hearing on it, things have kind of fallen off with the others.
Okay. What would be reasonable?
I would think perhaps just given with summer, maybe middle of July. I know there's a lot of parties and there's going to be a lot of different issues that they want to make sure T's get crossed and I's get dotted in terms of that this interlocutory appeal is done correctly. So that may be, that 60 days could be, I think, useful to work through that process. But I'll just add that the title claimants, the primary ones, aren't here, and so I don't want to speak for them without kind of knowing what all their concerns are. But that would be, in my estimation, a reasonable amount of time to get things teed up.
Yeah.
Judge, I suggested we contact the other parties, maybe come up with dates and present those to the court.
All right, I think 60 days is reasonable. If when you talk to the other parties, I think it's also reasonable to get their input. If that's not workable, or if it's going to, put a strain because of kids and vacations and all that kind of stuff, I'm totally open to listening to another date. But just as a way to start, let's aim for 60 days. This is not a ruling. It's not an order. It's just the judge would like to kind of get this thing moving because there is a lot of money tied up.
Your Honor, with regard to that, one thing I'd like to correct, I think XTO made a statement that it's not holding money. It is holding money from 32 and 41 that's separate from the outside properties that is not in the registry of the court.
Okay.
Yeah,
Okay.
It's continuing.
That's the title dispute funds.
Well, it's continuing to hold money from 32 and 41. And we've not been able to find out how much is in possession of XTO as to that sum, which we believe is way more than sufficient to satisfy any judgment that Mr. Cass might recover. So this outside money is a totally separate issue. It doesn't involve 32 and 41. This is money that XTO is claiming to own, and then we claim to own it. And so it has nothing to do with 32 and 41. But I did want to make clear that
Okay, well, how much money do y'all have in suspense for the 3240?
So Judge, we don't have that number because the what's in suspense is not just the overriding royalty interest on 32 and 41. It's a disputed royalty interest between RIM and CAS. It's disputed working interest between, at the time it was CAS and RIM. I don't know if RIM is still pursuing that, but there are a number of interests. And if it turns out that one party owns it, then the dollars can change because of the way that it's set up. And so there's a significant amount of money in suspense, but we can't necessarily, I don't know how it ties out to all of the different interests in dispute. And we wouldn't really know that until we get this title determination to see who owns what, is part of the problem in that respect.
well, Judge Leonard, we've tried to, through discovery, which the XTO started withholding this money before the lawsuit was even filed. The reason we filed the lawsuit was because of the seizure of the unrelated funds from the undisputed properties. And so we believe that the number that was filed, that they were holding in excess of 200,000 just for the override situation, and before we even became aware that there are other issues about working interest that we're not involved in. So there's a significant sum of money there in addition to the money from the unrelated funds that to take care of any issues which might arise from 32 and 41. And so that, I just don't see the money from the outside properties as having any bearing on 32 and 41. Again, that's why we seek a release of those funds.
And just to clarify, Judge, the money that's being held in suspense, that's a circumstance recognized Texas law, natural resources code, that when you've got title claimants both claiming to own, for example, the overriding royalty interest, well, then the operator's entitled to hold them in suspense until that title dispute is resolved. That's what's happening over there. As to, it's a separate issue.
Right, but what you're also trying to do is take the 200 and plus that's in the registry of the court and satisfy whatever debt on the disputed ownership. That's the thing.
Well, and here's the situation, Judge, because we suspended it once the title dispute became clear. What was paid out beforehand that had been paid out to the plaintiff on the disputed override, now that is money that because of the division order that we talked about earlier, if the plaintiff didn't own it, then the plaintiff would owe it back or to XTO. But also that's exposure that XTO faces from Mr. Cass, who does not have a division order.
Okay, well, you should know the number on that because you have the price and you have the interest. Does it go to this pot or does it go to that pot?
So I guess
for the override.
For the override, I'm sure we can figure out what that number is. I don't have it right now, because the pot of suspense is more than just the override, and so we haven't tried to isolate it down to what that is. But I do know, Judge, that the amount that was paid to the plaintiff since May of 2016, before things went into suspense, was over $600,000. So the plaintiff received on this interest that the plaintiff did not own over $600,000 to which it wasn't entitled. So that up to the suspense date, we know what those numbers are in terms.
And how much is within the statute of limitations of that 600?
560. I mean, a large amount.
Most of it.
Depending on what you calculate as the statute of limitations. Now, I'll make that caveat because the claim that XTO would be subjected to from Mr. Cass would be for 4-year statute of limitations, because that's not a.
Okay, that's that issue. So the 4-year statute of limitations, that's 560,000. Have you withheld have you withheld from the 41 and 32 properties more than the 560 from the plaintiff?
Well, so
On the override?
one, I don't know the answer to that, Judge, but those are monies that are just being held so that when the title determination is resolved, then they would go to that party. They would go to the correct party. And
But
so
how much do you have? You're not answering my question.
Yeah,
I think it's because you don't know. But if you have $800,000 sitting there in suspense from Mr. Thaggart, and you say, okay, I don't know who owns this, I might have to pay Mr. Cass 600 of it. You don't need the 200,000 that's in the registry of the court from other properties.
Well, so they're different time periods, though, I think is what the issue is. The amount that's in suspense is covering what would be paid to the owner from I think it was, I can't remember the exact date when things went into suspense, call it November of 2018. From November 2018 forward, what's in suspense is going to be paid out for that time period. So they haven't been received, nobody's received a payment on the override during that time period, and whoever ultimately owns it is going to get paid out of that money. What is in the what we're potentially liable for is
I see what you're saying.
From a double payment standpoint is what was paid out before that suspense amount. And that's that.
Okay, so you're not withholding all of. Let me think about this a minute. So if Mr. Thaggart has an override in 32, you're withholding that.
At the moment, yes, Judge.
Yeah, because that's a title issue.
Correct.
And so either you pay it to him because he truly owns it, or you pay it to somebody else, but you're not, there's nothing else, I guess, in that 32. Okay, I see what you're saying. I'm clear on it now.
And if it turned out